I've been taking my time, taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. And while I'm waiting, if you can hear me, let me know what number your thumbs up was. I'm gonna wait. There's a delay, so if y'all hear a pause, it's because I'm waiting to see if y'all can hear me. Okay, I see it. Okay. Good morning, Shirley Macklin, first in the building. Professor Purple Queen, Miss Tina, Daphne Brown, Purple Unicorn, Ty, Mimi, Veronica Monroe, as Chit Chat says. Hey, Sound Checker Neds, number 2 on the likes. Hey, Audrey Gavins and Green, IPV Lucky number 7, Distracting One with the pretty icon. Hey, hey, Miss Cutie Pie, Mama Bees, Darcy Ayers, Deborah Jackson, Sharon Godbolt. Okay, oh, I see you over here, Sharon. I know you be over there with me with the YSL stuff too. Let me see here. Hey, Glow, how you doing, Glow? Glow, if you change your picture, you got to remember, you got to remind me that that's you because I have another Gloria too, but I know I usually call you Glow. Okay. Hey, Hill 75, April with the 2 L's, Miss Main Event coming in at number 32. All right. Thank you, Michelle Williams, 23. I see you. Okay. And hey, I'm so fierce. All right. We're 2 short announcements and then we're jumping right into the things. So first of all, Don Don has 3 brunches coming up. And he has graciously identified me as a tour sponsor, which I really appreciate. And just so y'all know, no, I don't mix funds. So I don't mix your court document funds to go in there and sponsor my friend. I had a budget before YouTube, and part of my budget, my little, like the, what do you call it? The disposable income part of it, I supported my friends. So I just want y'all to know I'm not using your money to then go and put it somewhere else. If I say it's for court documents, it's for court documents. I want to make that clear because it be sounding like real big and stuff when you a sponsor and stuff. So I just want to make that clear. I'm not mixing funds. I'm not misappropriating my own little funds over here. But Don Don has a date for Dallas, Texas. It's September 15th. Then October 20th is Charlotte, North Carolina. And October 27th is Washington, D.C. Nightbot will be dropping the link if you would like to get your tickets. He has some pre-sale prices going on. So, take advantage of that if you're thinking of going. For me, I definitely claim the DC date next. So if you're going to DC, I will see you in DC. I can't wait for that. And then the other thing, and last announcement really for now is we will see you. Oh my God, there's another teaser coming out. There's another teaser coming out soon before Thursday. But we will see you Thursday, 7:30 p.m. Eastern Standard Time. And you can come to my channel. You'll catch it. And I can't give you more details until, we actually get to Thursday, 7:30 p.m. Eastern Standard Time. But here's our little teaser. All right, all right. So right. Not pulling a Stormy. Discretionary funds. Thank you, Miami J. Right. We're not doing that. I don't need y'all thinking I done started balling hard on people money. No. I'm blessed to at least, I still have my 9 to 5, which is why I get behind on information as it is. But yes, I'm too appreciative of y'all for funding these court documents, sponsoring these court documents. I don't want to jeopardize that. So I just want to say that because I'm like, man, Donna got me out here looking big and stuff. Okay, so now let's get to these court documents. All right, so today, let me give you a brief summary of the documents we'll be looking at. But I do say again in the title, now you see we are on part 3, which means if you don't want misinformation to be spread or you hear something and the information gets misconstrued on accident, watch part 1 and 2. So you can honestly know what's in the documents instead of me trying to summarize and I forget a detail, and then you might accidentally run with that. And then I don't want to do that. So I'm going through the full document. So just want to say that because it's so much and the timeline overlaps so much. And there's so many details. It's just like I'm gonna read to you what I see, and then you gotta take it from there because I can't remember all this. Okay, so here we are. Let's start with, all right. So what we'll be reviewing is, as an exhibit, LeBerick and his attorney attached the child custody agreement, the final divorce settlement agreement. I think it was a modification, but it wasn't labeled modification to the agreement. Also, the other motion for contempt. And it cites in here that because Destiny did not follow the court's orders, the deed was divested from her and only given to LeBerick. So you'll see that as well. Hey, thank you, distracting one. Spend as you see fit, trending hugs. Thank you. I appreciate the super chat. Let's pop the trunk early. We haven't seen our little guy in a while, so let's clap for a second. All right, we going.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
All right, thank you very much. All right. Let's see here. So let's go ahead and go through it, but that's just so you know what's kind of coming up. That's what we have. Custody terms, we'll see that. And also, like, how the medical insurance was split, stuff like that. Expenses for the child are split. We see in other terms about not talking negatively about each other and stuff like that. So that's all in here. Oh, I got to say this one. Hey, Messy Ho. Good morning. Good morning, Cricket. Hey, everybody. Okay. So verified emergency motion for order, directing entry of clerk's deed, motion for contempt, and motion for immediate order removing party from real property. And a plaintiff will be LeBerick, defendant will be Destiny. The plaintiff, by and through the undersigned counsel, states as follows. The plaintiff moves this court to order the clerk of Madison County, Alabama, to issue to the plaintiff a deed following the described property, the final disposition of which was ordered by this court through the incorporation of the parties' settlement agreement into this court's final decree of divorce entered by this court. The prior settlement agreement of the parties is attached hereto as Exhibit A, and we will review Exhibit A. The prior agreement of the parties provides in pertinent part as follows. Real property. Should the wife be unable to refinance the home by April 1st, 2022, the home shall be placed on the market no later than April 5th, 2022, with a realtor of the husband's choice. The marital home shall be sold at a price chosen by the husband, and upon satisfying the mortgage, the remaining equity shall be split equally between the husband and wife. The husband and wife shall execute all documents necessary to facilitate placing the home on the market and the sale of the home immediately upon receipt of said documents. This instance is far from the first time that the plaintiff has been forced to seek relief of this court to force the defendant's compliance with her own prior agreement. In the previous action between the parties, the plaintiff filed a verified petition for contempt upon the issue of the defendant's noncompliance with the sale of the marital, I'm gonna say they probably meant marital home, following the defendant's failure to refinance the mortgage indebtedness of said property into her own name. I just want to say this is now the second time I have seen that. The first time was when we went over when Destiny was evicted from the Madani space, and she was telling them, you can't evict me. I was planning on buying the property, and she did not get approved for the price that the sellers were selling it for. And she tried to say, well, that's not what it got appraised for, but their contract showed what they would sell it for, not appraisal price, but what they would actually sell it for. So she delayed on them as well. So if you'd like to see that, that's also in my Love and Marriage Huntsville playlist, which I'll eventually most likely move over to this Destiny LeBaric playlist, so you can just see her court cases in one spot. Most likely. But yeah, so this is a tactic that Destiny has used before. She's a delay person as well. Delay. So it says, said verified petition is attached hereto as Exhibit B. Thereafter, the plaintiff was forced to file his second verified motion for contempt due to the defendant's frustration of the sale of the former marital residence, including but not limited to the defendant's failure to cooperate with real estate agents, refusal to allow access to the home for the purpose of showing, and the defendant's removal of the realtor's for sale sign from the home's yard on at least 3 separate occasions. Said second motion is attached hereto as Exhibit C. The parties settled the .01 action by way of a settlement agreement attached hereto as Exhibit D, executed by the parties dated April 28, 2023, which provides in pertinent part as follows. Contempt. All claims of contempt brought in this action are hereby dismissed, but it was without prejudice, meaning it could be revisited upon any further instance of contempt committed by a party and the filing of a petition before this court thereon. The parties may revive claims of contempt made in this action for final disposition in any subsequent action. Said agreement was incorporated into a final order of modification of this court dated May 1st, 2023. This contempt action was filed by the plaintiff on or about September 20th, 2023. The defendant was served with said petition on September 21st, 2023. Thereafter, the plaintiff filed a motion for emergency hearing related to the defendant's interference with the closing on the former marital residence on September 22nd, 2023. I just want to let's recall one memory I actually remembered that I have, and let me know if y'all remember it, but do you remember when Destiny was like, of course I'd be there for the sale of the house. My name is on the deed. Well, it wasn't on the deed by the time the house sold, I believe, because they removed her name and it all went to LeBaric. So it was just funny. She said something to those lines like, of course I'd be there because it was my house too. But at the very, very end, it wasn't both their houses anymore. It started with both their names on it, but that the court ordered differently. It says this court held an emergency hearing upon the plaintiff's motion on September 27th, 2023. Thereafter, the court ordered as follows. The defendant must vacate the former marital residence no later than 12 a.m., which will be midnight, on the morning of September 29th, 2023. The defendant shall also have all items of personal property removed from the residence at said time. Another observation is outside looking in without details. I believe it sometimes was painted as she was divorced, or, he filed for divorce and then immediately was like kind of kicking her out the house. But apparently she signed agreements of knowing the dates of when she have to vacate if she didn't refinance and all that stuff. So it wasn't a just, I'm divorcing you and get out my house. Now, here's what I'll say again. I don't know LeBaric either, so I'm not going to go too strong for LeBaric, but I'm just saying that one of the things that was painted does not seem to be true about how she just had to get her stuff and get out immediately. That's not what was happening. There were agreements mutually signed, and then she just wasn't actually following them, court orders and stuff like that. Okay, so now it says and she had the first time she had to be out the house by April 2022. And that was unless she refinanced the home. Then they had another agreement they signed to, I guess, what she had to be out maybe in 2023-ish, or just don't prevent the sale of the home. But anyway, it says the defendant failed to vacate the former residence by the ordered date and time. As of the filing of this motion, upon information and belief, the defendant has still failed to vacate the residence. Rule 70 permits the court to issue judgment for specific acts, including the vesting of a title of property for the purpose of carrying out a prior order of the court. Specifically, the rule provides as follows. If a judgment directs a party to execute a conveyance of land or to deliver deeds or other documents or to perform any other specific act, and the party fails to comply within the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act, when so done, has like effect as if done by the party. On application of the party entitled to performance, the clerk shall issue a writ of attachment or sequestration against the property of the disobedient party to compel obedience to the judgment. The court may also, in proper cases, adjudge the party in contempt if real or personal property is within the state. The court, in lieu of directing a conveyance thereof, may enter a judgment divesting the title of any property and vesting it in others, and such judgment has the effect of a conveyance executed in due form of law. When any order or judgment is for the delivery of possession, the party in whose favor it is entered is entitled to a writ of execution or assistance upon application to the clerk. The plaintiff acknowledges that the present circumstances are an atypical application of this court's authority under Rule 70. However, an application nonetheless made necessary by the defendant's complete and utter failure to comply with the orders of this court. I actually would like to see that too. Changing the for sale signs. The plaintiff requests this court enter an order directing the clerk of this court to issue to the plaintiff a deed to the subject property so that closing of the real property may go forward and the plaintiff may carry out the sale of the home as required by this court's prior order. A copy of the last deed of record relating to said real property is attached hereto as Exhibit E, and a copy of the proposed deed for the clerk's execution is attached to hereto as Exhibit F. As grounds for said request, the plaintiff states that the defendant has failed and refused to execute and deliver necessary documents to effectuate the sale of the property, notwithstanding that the divorce decree specifically ordered the same. The defendant is therefore in civil and criminal contempt of court. The said failure has resulted in significant inconvenience and expense to the plaintiff and continues to impair rightful ownership of the said property. Upon information and belief, the entry of a judgment in the form of a clerk's deed, divesting the defendant the title to the property, and vesting said title into the name of the plaintiff will permit the closing of the real property to go forward as scheduled, which will allow at last the execution of this court's prior order. As the defendant testified before this court at the emergency hearing held on this matter, the defendant intends to, quote, run out the clock by refusing to execute the required documents to effectuate the sale of the former marital residence, and instead file bankruptcy at some unspecified time in the near future so as to delay indefinitely the sale of the marital residence. And she did eventually file for bankruptcy, and LeBerick had to, in fact, they had court on Valentine's Day. Was it 2024 Valentine's Day? They had court about her bankruptcy. And basically he was trying to make sure he was named as someone, even if the bankruptcy went through, she would still owe the debt that she owed, or she would still have to have her obligation so it would not harm him and what he needed. I'll say that because I can't remember if she actually owed him money or it just would hinder him from claiming the properties or things that he needed to claim. As additional requested relief, the plaintiff moves the court to enter an order directing the sheriff to physically remove the defendant from the said real property. As grounds, the plaintiff states that the defendant has failed and refused to vacate the said real property as ordered under the prior decree and prior order entered thereafter enforcing the said prior decree. Wherefore, the plaintiff requests the court to grant the petitioner the following relief. Finding the defendant Destiny Williams to be in knowing and willful civil and criminal contempt of the court's prior orders by punishing the defendant for said contempt as allowed by Alabama law, including 5 days incarceration for each separate act of contempt, by punishing the defendant for said contempt as allowed by Alabama law by imposing a fine, by awarding the defendant attorney fees and costs incurred in this matter, by ordering the clerk of Madison County, Alabama, to issue to the plaintiff the deed referenced herein above, by entering an immediate or order directing the sheriff to take steps to physically remove the defendant from the said real property by granting any additional relief to which in equity and good conscience the plaintiff may be entitled in the premises. Okay, and then they signed it. LeBerick notary signed it. His attorney signed it. Now we get to, this was the settlement agreement, the original settlement agreement. And I think some things were modified from here, but at first this was the settlement agreement executed April 9th, 2021. Right. Right. It's a little wild, Purple Unicorn. And thank you very much, Catherine Chapman. I appreciate that. That's a very nice thing to say. Thank you so much. Okay. Let me see. So it says this agreement, which is made, entered into, and executed on this, the 9th of April, 2021, by and between LeBerick Williams, hereinafter referred to as husband, and Destiny Williams, hereinafter referred to as wife. Whereas the parties hereto are husband and wife, having been married to each other on September 7th, 2019, in West Point, New York, and lived together as husband and wife until they separated. One child was born, and no other children are expected. The wife is not pregnant, whereas during the existence of said marital union, certain properties and property rights have been accumulated by the parties hereto, whereas a complaint for divorce has been brought by the husband and the parties are mutually desirous of adjusting their respective property rights and personal affairs, and each of the parties hereto are determined not to live together as husband and wife and desire to define the relationship between them by entering into an agreement which provides for the proper disposition of their joint and several properties, the determination of other rights existing between the parties, and the proper handling of joint liabilities and responsibilities incurred by the parties. This agreement shall, subject to the approval of the court, be incorporated by reference into and made part of any decree of divorce which might result from the divorce action as filed. Therefore, in consideration of the mutual covenants hereinafter contained and of the recital set forth above, it is agreed by and between the parties as follows. So this was their agreement at first. Mutual releases. The husband does hereby release and relinquish the wife from any and all liabilities and obligations which she may owe unto him by reason of their marital relationship, and any right, interest, or claim which he may have in and against her estate by reason thereof, except as herein provided and agreed. And the wife agrees the same. She releases the husband from any and all liabilities and obligations, except what was agreed to. Grounds. So the grounds for the divorce cited is the plaintiff shall be granted a divorce on grounds of irretrievable breakdown. So that's their overall grounds. The child custody and support. It says the parties shall have joint legal and physical custody of the minor child. The wife shall have primary residence of the minor child until the minor child is 3 years old. The parties shall each exercise visitation in accordance with the 23rd Judicial District Joint Visitation Schedule, with the following modifications. Beginning April 7th, 2021 until December 1st, 2021, the husband shall have the minor child from Monday until Wednesday each week. Beginning December 1st, 2021 until June 1st, 2022, the husband shall have the minor child in accordance with the 23rd Judicial District Standard Visitation Schedule. Beginning June 1st, 2022 until June 19th, 2023, the husband shall have the minor child in accordance with the 23rd Judicial District Standard Visitation Schedule, and on the weeks that the husband does not exercise weekend visitation, the husband shall have visitation beginning Wednesday until Friday. Beginning June 19th, 2023, the husband shall have minor child in accordance with the 23rd Judicial District Joint Custody Visitation Schedule. The husband and wife shall exercise visitation on a week-on, week-off basis. All exchanges, pick-up, and drop-off of the minor child they'll occur at address. The parties shall follow the 23rd Judicial District Joint Holiday Visitation Schedule. In addition to the foregoing agreements concerning the child, the standard parenting clauses attached hereto as an exhibit shall be incorporated herewith as if fully set forth. The parties shall communicate with one another regarding all significant decisions to be made for the minor child. They shall listen and consider the desires of the other parent and review and consider any materials presented by the other parent. If the parents are still unable to agree on the course of action, then the party shall be assigned areas of ultimate decision-making as follows. Medical and dental care, wife, but we'll go into more detail about medical and dental care because I was like, wait, wife for medical and dental, but we're going to go into more detail about medical and dental. Education, husband. Religion, wife. Cultural, wife. Sports and extracurricular activities, husband. Civic, husband. The provision for child custody in this decree constitutes a custody decree or custody determination under the Uniform Child Custody Jurisdiction and Enforcement Act. The husband shall be responsible of 50% of all mutually agreed upon child's extracurricular activities. In the event either party advances extracurricular activity fee charges or pays the other party's portion, then in that event, the party incurring the expense shall provide proof of the payment to the other party within 30 days of the expense, and the paying party shall be entitled to reimbursement by the other party within 30 days of the payment of the same. The husband shall not pay child support to the wife for the minor child. The child support calculated herein is not in compliance with Rule 32 guideline support, and the necessary guidelines and notice of compliance have been signed and filed herein. The parties acknowledge that they are not utilizing the Rule 32 formulas, and the joint custody agreement is a justification for deviation from Rule 32 support. The parties believe the deviation is fair and reasonable considering the agreements they have made relative to expenses and their current income levels. So just this is what was mutually signed. It says the parties believe that it's fair and reasonable with not paying child support and these other agreements we're going over. They mutually agreed to them. Okay. It says the wife shall claim the minor child as a dependent for income tax purposes for the years 2020, 2021, and 2022. The husband shall claim the minor child as a dependent for income tax purposes on odd numbered years beginning for tax year 2023, and the wife shall claim the minor child as a dependent for income tax purposes on even numbered years beginning for tax year 2023. The husband and wife shall discuss any potential contracts relating to the minor child, and all contract obligations involving the minor child shall be agreed by both the husband and wife. Neither party shall hinder the minor child from accepting and fulfilling any contract obligations that are in the minor child's best interest. If the parties are unable to agree that the contract or the contract obligations are in the minor child's best interest, then the party shall file the proper petition with the court to obtain a final answer. The wife she can film with the minor child in commercials on Love and Marriage Huntsville, any spinoff show, and the like. All proceeds received from any contract made on behalf of, with, or for the benefit of the minor child shall be placed into a trust for the minor child. Both the husband and wife shall have access and control of said trust account until the minor child reaches the age of majority. So she's not restricted from filming with her son. Health insurance. The wife shall obtain her own health insurance for herself immediately, as she will be removed from the husband's policy. The husband shall continue to maintain major medical and hospitalization and dental, if available, insurance coverage for the minor child, which coverage shall be maintained for as long as such group insurer allows, i.e., if a full-time student, coverage may be available beyond a child's age of majority. The husband shall pay and be responsible for all premiums for the same. With regard to all medical and dental expenses incurred for the child, including orthodontic, optometric, ophthalmological, and prescription medicine not covered by said policy of insurance, the husband shall pay 50% of all uninsured medical and dental expenses, as described above, incurred by the minor child, and the wife shall pay 50% of the same. So beyond what's covered by insurance, that's when they start going 50-50 on medical. The husband shall provide the wife with insurance identification cards for her use for the minor child, as well as executed forms, updated benefit schedules, and any other documents she would need to utilize said insurance coverage. In the event either party advances medical and or dental expense as described here and above, which are either uninsured or non-covered by insurance or paid in advance of insurance reimbursement as a requirement of the service to the minor child, then in that event, the party incurring the expense shall provide proof of the payment to the other party within 30 days, and the paying party shall be entitled to reimbursement by the other party within 30 days of the payment of the same. I have the judge's name, Lisbeth, so I can't remember that other judge's name, but we'll see the judge, I believe, signing some of these orders. So we'll see if it's the same judge or not. Okay, alimony. The wife waives all claims to alimony. Personal property settlement. Husband. The husband shall be granted sole right, title, interest, use, and possession of his clothing, jewelry, diamonds, gold, personal effects, family heirlooms, premarital property, items given to him as gifts, balances in any banking account held in his individual name, any property currently in his possession, and all property items listed on Exhibit C. The wife is hereby divested of all right, title, and interest to the same. Let me insert my opinion real fast, just so y'all know. I think this agreement very heavily favors LeBeric. I can acknowledge that. Now, my opinion on if that's good or not, I don't know. But I'm just letting you know, I do see that this agreement heavily favors LeBeric. Destiny, we know her finances are not the best. She's not getting alimony. They have joint custody, so there's no child support. She can film with the son, but that's not really going in her pocket. It has to go to a joint trust. You know what I mean? So like, I'm just saying, now she signed this too, so she had agreed to it. But I'm just saying, it heavily and then I don't even know, because I don't even know if she had a good attorney to ask to see all of his accounts before she signed this agreement. Because if he gets everything premarital that he had, and then any current bank accounts that's just in his name, it's like you don't even know what was holding out there. That's all I'm saying. So I just want to acknowledge that I see that. Okay, personal property settlement, wife. The wife shall be granted sole right, title, interest, use, and possession of her clothing, jewelry, diamonds, gold, personal effects, family heirlooms, premarital property, items given to her as gifts, balances in any bank account held in her individual name, and any property currently in her possession except those items listed on Exhibit C. The husband is hereby divested of all right, title, and interest to the same. Real property. The husband and wife own the marital home. The home is financed and deeded in jointly in the husband and wife's name. The wife shall have until April 1st, 2022 to refinance the marital home. The wife shall remain in the marital residence until April 1st, 2022, and the husband shall be responsible for the mortgage and escrow payments until April 1st, 2022. So that part's in black and white where he was responsible for mortgage and escrow payments, and it's going to say what she was responsible for while she was in the home. But so he was paying the mortgage when he was no longer living there. Upon refinancing, the present mortgage on the home shall be satisfied, and the equity in the home shall be equally split. The wife shall refinance the home for an amount that will cover the husband's 50% of the equity. The wife shall pay the husband his 50% of the equity on the day of closing. The husband shall execute any documents necessary to facilitate the wife's refinance and the removal of his name from the property. Should the wife refinance prior to April 1st, 2022, the husband shall not be responsible for the mortgage payments associated with the refinance. In the event that necessary maintenance or repair costs arise while the wife is occupying the residence, she shall pay and be responsible for 100% of the cost. The wife shall not damage the marital residence or surrounding property during her tenancy. Should the property become damaged, the wife shall be responsible for all costs associated with the repairs. The wife and the party's minor child shall be the only persons authorized to occupy the marital residence until it is either refinanced or sold. And y'all know in his 2023 petition for contempt, he alleged a former employee was sleeping overnight at the marital residence. There shall be no one else living, residing, renting, subleasing, or staying for more than 72 hours at the marital residence. The wife shall not be authorized to assume the VA loan on the marital residence. The wife shall not place any liens or there it goes. The wife shall not place any liens on marital residence. So y'all did educate me and say that it still could be sold with liens, but she wasn't supposed to have liens on that house from her debts. It says place a second mortgage on the marital residence or authorize any third parties to place a lien on the marital residence. And she had 2 liens on the marital residence from his most recent petition that he had filed. Let me see. He wasn't playing. Good morning, PK Joe. Do you think it's because he agreed for her to stay in the home for 12 plus months? I do. I think she waived alimony. She waived so many things because she was able to stay in the home without having to pay the mortgage and just having to keep up with the maintenance and the HOA fee. I do think that has something to do with why she waived so many other things. I really do, because I'm like, what was your benefit? So that if you do it right, I mean, that's still not a long-term solution, but maybe she needed the immediate financial solution. What you should be trying to do is save what you would have paid in mortgage, save that money, so then you're in a good spot when you have to vacate the home. And And then, of course, she didn't get approved for refinancing. So we know that she's not in that house. It did get sold. Okay. Yeah. Now, see, here's the thing. Cece, her name was on it. And now we're getting to a deed that removes her name from it because she was preventing the sale of the house. That's what's crazy. So her name in the end, now she still may have gotten her 50%. I don't know what court documents we're going to see later. So she may have still gotten her 50% equity. I'm not sure. She might have had to, at the end, that might be where that some of that 19K came from. I don't know. That's why we're all looking at this together. So I don't even know if she actually kept her 50% equity or was granted her 50% equity by the time we get to the end. This is just part 3. Okay. Joyce, she got sued for that too. She was held in contempt for the song on 10 because it talked about him. She did not really get to. She did. Joyce, I know you meant well, but no, Joyce, that was named in the contempt petition as well. The on 10 was referenced. It's crazy. Simone says, also in my tripping, but wasn't Destiny a realtor? I vaguely remember her showing Melody her current home when she was divorcing hotel. No, I heard, yes, I heard. Well, what was it? Okay, she was in real estate. Did she ever get her license? And maybe she did, and then it lapsed. I don't know how that works because it seemed like we had talked about that in a video before, but yes, you're not wrong. She was involved in real estate and I think was a realtor at one point. I don't know if she still has a license or had a license. I don't know. But you aren't wrong in remembering that. Okay, it says, should the wife be unable to refinance the home by April 1st, 2022, the home shall be placed on the market no later than April 5th, 2022, with a realtor of the husband's choice. The marital home shall be sold at a price chosen by the husband, and upon satisfying the mortgage, the remaining equity shall be split equally between the husband and wife. The husband and wife shall execute all documents necessary to facilitate placing the home on the market and the sale of the home immediately upon receipt of said documents. Pending the sale, the wife pending the sale, the wife shall have the right to occupancy of the residence. So that's where she was running the clock down. That's what they quoted that she said in the emergency hearing. Okay, Simply Beautiful said, Melody said she found that house. That was a scene she produced so Destiny could have camera time. Bring out the red phone, Mel. Oh my God. Simply Beautiful. Oh my gosh. Oh Lord. The way you try to help a friend, man. The way you try to help a friend. Please like the video. Thank you, everybody. Goodness. Thank you, Simply Beautiful. Okay, so pending the sale, she had the right to occupy the residence. The husband shall be authorized to come inside the marital residence for necessary reasons related to the sale of the home. The wife shall keep said property in a clean and presentable condition at all times for showing to prospective purchasers and make the residence available for showing upon reasonable notification by the realtor. Debts to be assumed by the wife. The wife does agree and covenant to pay and be responsible for the debts now existing as incurred by her, except for those debts listed herein as assumed by the husband, whether incurred in the individual or joint names of the parties hereto, and further, if legal action is brought against the husband to recover any debt thereon, the wife agrees to indemnify or hold the husband harmless, and in addition to pay any attorney's fees and costs of collection which he may incur as a result of her failure to pay said indebtedness. All debts in her name, only including but not limited to credit cards, personal loans, student loans, hospital bills, etc. The payments associated with the Mercedes SUV she recently leased. Oh, Destiny. Oh, not leasing the Mercedes, and no other joint debt. Okay. Debts to be assumed by the husband. The husband does agree and covenant to pay and be responsible for the debts now existing as incurred by him, except for those debts listed herein as assumed by wife, whether incurred in the individual or joint names of the parties hereto, and further, if legal action is brought against the wife to recover any debt thereon, the husband agrees to indemnify or hold the wife harmless, and in addition to pay any attorney's fees and costs of collection which she may incur as a result of her failure to pay said indebtedness. All debts in his name only, including but not limited to auto loans, credit cards, personal loans, student loans, etc. No other joint debt. Retirement, except as provided herein above in provisions 6, 7, 8, 9, and 10, each party will obtain sole right, title, interest, use, and possession to any checking, savings, financial accounts including retirement accounts, investment accounts, IRA, annuities, variable annuity, life insurance, pension, military retirement, which I agree with. Prior military, I agree with. They didn't even make it. What do they have to make it to? What, is it still 10 years? You make it to 10 years, I understand why you're getting some of my military retirement. You don't make it to 10 years? No, you're not touching my stuff. But 403B, employee stock ownership, profit sharing, thrift savings, I looked up how to pronounce that name before. I'm so sorry. KEOGH, and stock option plans held and or maintained in his or individual name. The other party is hereby divested of any right, title, use, or possession to any of the other party's financial accounts, including retirement accounts, investment accounts, IRA, annuities, variable annuity, life insurance, pension, military retirement, 403B, employee stock ownership, profit sharing, thrift savings, and stock options plans held and or maintained in the other party's individual name. Miscellaneous provisions. The parties hereto do hereby covenant and agree, each with the other, to execute all papers and documents, including deeds, bills of sale, as shall be necessary to fully and finally consummate this agreement. The husband and wife covenant and agree that they have reached a satisfactory agreement as to the fair and equitable division of any and all other assets and properties, either real, personal, or mixed, and of any nature whatsoever, which they may own or have any interest in. Further, that each fully disclose to the other the nature and value and location of all said properties, and that each is relying on these disclosures in executing this agreement, and is further being induced to execute this said agreement as a result of said full disclosures. The parties hereto do hereby covenant each with the other the following: that each shall refrain. This is the other contempt part, y'all. This is why the On 10 song is in the petition, her interviews, but not the Dear Future Wifey interview. That was not cited because the Dear Future Wifey interview happened a few months after he filed his petition for contempt. So that one's not in there, but there's other interviews, including the Instagram Live is in there. The song On 10 is in there. So this is what it says. Each shall refrain from any and all words, conduct, deeds, and activities which are intended or calculated to interfere with, abuse, embarrass, or intimidate the other, and that each will respect the privacy of the other from and after the date hereof, that each will refrain from any activity, words, or deeds intended or calculated to interfere with the employment of the other, or calculated or intended to interfere with the family or social life of the other. The parties and members of the family shall each refrain from assaulting, contacting in person, contacting by telephone, threatening, harassing, interfering with the employment of, or coming onto the place of employment of either party. Further, the parties and members of the family shall refrain from coming around the residence of either party, talking to, striking, molesting, cursing at, injuring, or beating either party. The parties shall refrain from calling each other at their respective places of employment. The wife shall not speak of the husband, his family, or the like on the television show that she is associated with, namely Love and Marriage Huntsville, either directly, indirectly, or implied. The parties respectfully acknowledge that this agreement constitutes the entire understanding between the parties and supersedes all and any other prior agreements, if any heretofore made between them other than those herein expressly set forth. The parties further respectfully acknowledge that each has signed this agreement freely and voluntarily. It is agreed between the parties that this agreement shall be filed in the Circuit Court of Madison County, Alabama, in that divorce action contemplated, and it is acceptable by the parties that the provisions of this agreement, if acceptable to the court, shall be incorporated into and made a part of the final judgment of divorce of said court and said cause. It is further agreed, however, that in the event a final judgment of divorce is not granted in that action herein contemplated, or in the event this agreement is not acceptable to said court for the purpose herein above set out, the same shall be and become null and void, and shall not be evidenced or considered as such by any court. Okay. And then just to show, LeBerick signed it April 9th, 2021. And Destiny signed it April 9th, 2021. Okay, 1 second. I still have a couple of exhibits to show y'all. Okay, so this one is the verified motion for contempt. This is the one prior to September 2023. This is from April 13th, 2022. Verified motion for contempt comes now the plaintiff in the above style case and moves the court to enter an order finding the defendant to be in civil and criminal contempt of the court's orders. As grounds, the plaintiff states as follows. This is an action based on the plaintiff's claims of contempt against the defendant under this court's prior orders. On April 12, 2021, this court entered a final decree of divorce, incorporating into said judgment the settlement agreement executed by the parties, which lays out the course of action to be taken in regards to the real property. Said settlement agreement states that the defendant shall have until April 1st, 2022 to refinance the marital home, and if she is unable to do so, then the home shall be placed on the market no later than April 5th, 2022 with a realtor of the husband's choice. On March 2nd, 2022, counsel for the plaintiff reached out to the opposing counsel via email to remind said counsel of the upcoming deadline to refinance the marital residence. On March 4th, 2022, the opposing counsel, which would be Destiny's counsel, responded stating that their client had not received the documents necessary from the plaintiff to complete the refinancing. So let's pay attention to this. They're beyond the dates of refinancing. She had, from the time that they had their agreement, which it looks like 2021, April 9th, 2021, the home had to be sold by April 1st, 2022. She had to have refinanced by April 1st, 2022. Just now, Destiny is claiming via her counsel she never received the documents needed from LeBaric to refinance the home. I'm sure that the judge asked, please show me the communication between your attorney to his attorney or whoever, how y'all contacted each other, where you repetitively asked for any documents you needed to successfully refinance this home. I have to believe that the judge asked that. But y'all, so a month before the house should go on the market, so 11 months. No, hold on. 11 months before, after this was set, and 1 month before the deadline of having to put the house on sale if it wasn't successfully refinanced, the attorney for Destiny is saying, my client never received what she needed from LeBaric to refinance this home. It says, counsel for the plaintiff responded on March 10th, 2022, with an attachment showing copies of all the necessary documents that the plaintiff had sent to the defendant on February 2nd, 2022. The plaintiff also sent a text message alerting the defendant to the emailed documents. Counsel for the plaintiff did not receive a response. On March 28, 2022, counsel for the plaintiff reached out to the opposing counsel once again to inquire about the status of the refinancing or if it was necessary to begin the process to have the marital residence listed for sale. The counsel for the defendant has yet to respond as of this date, April 13, 2022. The plaintiff informed the defendant on Wednesday, April 6, 2022, that the broker was sending her listing documents requiring the defendant's signature. So LeBaric and his counsel said they sent the documents February 2nd, 2022. So for me, that leads me to believe that she asked for those documents in February, maybe give her late January. But what about the 10 months before that? I'm just wondering, because I know for me, to make sure I get everything in favor, I'm gonna list every time that I sent the documents needed. But that's what she does, y'all. When we look at the Madani eviction, that's what she does. It was Leroy and Barbara. They own the property of the Madani space, and she was doing kind of the same thing to them. As of today, April 13th, in my opinion, how I observed it, because I don't have a legal background. As of today, April 13th, 2022, the documents sent to the defendant requiring her signature to list the marital residence have not been signed. Thus, the plaintiff is unable to list the house on the market to sell and satisfy the mortgage or receive his 50% of the equity in a timely fashion. The broker employed by the plaintiff for the sale of this real property has a buyer lined up, prepared to purchase the property. The plaintiff is in need of an order compelling the defendant to fulfill her obligation so that he may complete the transaction and release his name from the debt owing on said property. The defendant has been late to the custody exchanges several times and has falsely accused the plaintiff of being verbally aggressive at these exchanges. The defendant is therefore in civil and criminal contempt of court. the plaintiff has incurred attorney fees as a result of the defendant's defiance of the court's orders. Okay, and we read what he prayed for before, so I won't read that again. And then we have the signatures of the notary and him. Okay, let me see. So now we're going to another exhibit. Okay, Exhibit C is the second verified motion for contempt. It says, comes now the plaintiff in the above style case and moves the court to enter an order finding the defendant to be in civil and criminal contempt of the court's orders as grounds the plaintiff states as follows. So this was, okay, so he filed for contempt a second time in March of 2023. The current one that we were reading in part 1 and part 2 was September 2023. So these were the ones before that one that we were reading. It says, comes now the plaintiff in the above style case and moves the court to enter an order finding the defendant to be in civil and criminal contempt of the court's orders. As grounds, the plaintiff states as follows. This is an action based on the plaintiff's claims of contempt against the defendant under this court's prior orders. The plaintiff has made earlier claims of contempt in both his petition for contempt and his verified motion for contempt. All previous claims made are incorporated herein. On April 12, 2021, this court entered a final decree of divorce incorporating into said judgment the settlement agreement executed by the parties and adopting this court's standard parenting clauses. On August 16, 2022, this court entered a consent order previously agreed upon by the parties. The defendant has willfully and deliberately defied the court's orders as follows. The defendant has consistently failed and or refused to respect the privacy of the plaintiff by publishing details related to the husband, his family, and his career on a variety of media outlets, including social media. In particular, the defendant now claims to be writing a book about her divorce, wherein she attempts to defame the plaintiff and divulge private details. She has been promoting that book on social media, including by conducting interviews specifically about the plaintiff and his family. The defendant has refused to give the father reasonable telephone access to the minor child while the child is in her custody. The defendant has failed or refused to reimburse the plaintiff for her portion of uninsured medical expenses. The defendant has failed or refused to inform the plaintiff of medical appointments of the minor child. The defendant has refused to provide makeup days to the father for missed visitation as required by the parties' previous agreement. The defendant has failed to refinance the former marital residence and is frustrating all attempts to sell the marital residence by refusing to cooperate with the selected real estate agent, refusing to provide the real estate agent access to the house, refusing to allow the house to be shown to potential buyers, and removing for sale signs from the residence on at least 3 separate occasions. The defendant is refusing to pay her portion of necessary repairs for the former marital residence. Despite assuming the full cost of all mortgage and escrow payments on the former marital residence, the defendant has failed to make said payments in the full amount and in a timely manner. And what that last one means is despite the plaintiff, LeBaric, assuming the full cost of all mortgage and escrow payments of the marital residence, the defendant, Destiny, has failed to make said payments in the full amount and in a timely manner. The defendant is therefore in civil and criminal contempt of court. The plaintiff has incurred attorney fees as a result of the defendant's defiance of the court's orders. And then, okay, this one I'll read again, this section, bullet D, that the defendant, Destiny Williams, be further and more specifically enjoined from further disparagement of the plaintiff on any and all media appearances, as well as be enjoined from publishing a book disparaging the plaintiff and his family. That removing the sale sign is getting me too. Okay, and then we know the other ones that he prayed for because those are repeated. So 1 second, let me see here. Okay, now this is a settlement agreement from April 28th, 2023. So this is their settlement agreement. This settlement agreement is made between LeBaric Williams of the state of Alabama and Destiny Williams of the state of Alabama. Okay, it says a petition for modification and a petition for contempt has been filed in this action in the Circuit Court of Madison County, Alabama. Whereas the parties hereto have agreed to settle all pending issues in this action and have agreed to a modification of certain provisions contained in the prior judgment entered by the court. Now, therefore, for the reasons set forth above and in consideration of the mutual covenants and promises of the parties hereto, the parties covenant and agree that the prior decree of the court shall be modified as follows. So now this is a modification from what I read 20 minutes ago or so. This is their child custody and other settlement agreements. It says the parties shall hereafter share the true joint physical custody of the minor child of the parties beginning on April 10th, 2023. The party shall abide by the custodial schedule and other provisions contained in the joint physical custody schedule and parenting clauses attached hereto as Exhibit A. The mother will begin her first 7-day rotation under this agreement beginning at 6 p.m. on Sunday, April 9th, 2023 at 6 p.m. The father will begin his first 7-day rotation under this agreement beginning at 6 p.m. on Sunday, April 16th, 2023 at 6 p.m. The parties shall continue to alternate weeks of physical custody of the child on Sundays at 6 p.m. thereafter. The father shall continue to possess final decision-making authority as to the child's academic programs or other such programs available through the child's daycare or other such early childhood education or care program. The father shall select an academic program among the options available at the child's daycare for the child to participate in during the child's daycare periods. The location for all custody exchanges shall be the Huntsville Police Department. Deviation from this provision shall be permitted only by mutual agreement in writing. Each party shall be entitled to reasonable telephone contact with the minor child during the custodial time of the other parent. At a minimum, each parent shall be entitled to a daily telephone call with the minor child at 4:30 p.m. during the other parent's custodial time. Parties' understanding of child provisions. It is agreed and understood that any payments for support, maintenance for education agreed to be paid here and above shall not abate, cease, or be reduced during any custodial period of the child with the other parent, regardless of the length of such custodial period. The parties understand that the provisions in this agreement concerning the child may be changed by the court at any time because of changed conditions or circumstances taking into consideration the interests of the child and the means and the resources and circumstances of the parties. It is the opinion of the parties that this agreement as concerns the child is fair and reasonable under the existing circumstances and is in the best interest of the child. The parties agree to attempt to work together in the future for the best interest and welfare of the child, setting aside any ill feelings they might have for each other. Contempt. All claims of contempt brought in this action are hereby dismissed without prejudice. So this is where the modification came. And all the previous times he asked for civil and criminal contempt, they dismissed it with this modification back in April 2023 without prejudice. As we see, it comes back up in September of 2023. Upon any further instance of contempt committed by a party and the filing of a petition before this court thereon, the parties may revive claims for contempt made in this action for final disposition in any subsequent action. The former wife shall comply with the prior order of this court, awarding the former husband the 2 large floor mirrors in master bedroom as denoted on Exhibit C. That's giving me a chuckle about these mirrors. Oh my gosh. As denoted on Exhibit C to the settlement agreement of the parties' original divorce action. The former wife shall deliver said mirrors to the former husband within 14 days of the entry of the final order herein, or the former wife shall pay to the former husband $750 for the value of said property. Upon delivery by the father to the mother of proof of medical expenses incurred by him and heretofore unreimbursed by the mother shall pay to the father $1,500 for the same. Said sum shall be paid by the mother within 60 days of the entry of the final order herein. Attorney fees. The former wife shall pay the former husband $5,000 in attorney's fees incurred in the above entitled 0.01 action. Said attorney fee payment shall be made to the former husband from the net sales proceeds of the sale of the former marital residence at the closing of said residence. To account for said attorney fee payout, the original dollar amount of net sales proceeds each party would have received at closing absent said attorney fee payout shall be determined, and at closing the former husband shall receive $5,000 more than his 50% portion of the said sales proceeds, and the former wife shall receive $5,000 less than her 50% portion of the said sales proceeds. So that $5,000 attorney's fees was back then awarded to LeBerick, and it would just be taken out of their 50% split of the equity of the sale of the home. It says court costs shall be taxed as paid. Oops, where's my mouse? Preparation of agreements. The settlement agreement has been prepared by the joint efforts of the respective attorneys for each of the parties. This settlement agreement should be interpreted fairly and simply and not for or against either of the parties. Hold on, let me make sure. Okay, yeah. The consideration for this contract and agreement is the mutual benefits to be obtained by both of the parties hereto and the covenants and agreements of each of the parties to the other. The adequacy of the consideration for all agreements herein contained is stipulated and admitted by the parties. Each of the parties shall on demand execute and deliver to the other any deeds, bills of sale, assignments, consents to change the beneficiaries of insurance policies, tax returns, and other documents, and do or cause to be done any other acts and things as may be necessary or desirable to effectuate the provisions and purposes of this agreement. If either party fails on demand to comply with this provision, that party shall pay to the other all attorney's fees, costs, and other expenses reasonably incurred as a result of such failure. So this is why I'm like, Destiny, how much do you give your attorneys to go off of? Because getting closer to present day, Destiny, when she filed her answer to the petition, she said that he should pay her attorney's fees because she has to respond to that petition and be in court because of him. But he keeps getting in writing by court order that if she goes against their agreement, she owes his attorney's fees. And it's just like, are you providing your attorney these documents that happened in the past? I just wonder, because I'm like, I would have to really, really fight as an attorney. Don't make me put this in here, because look at the agreement. Look at what you signed. And it kept repeating fair and reasonable, fair and reasonable. Partial invalidity. If any provision of this agreement is held by a court of competent jurisdiction to be invalid, void, or unenforceable, the remaining provisions shall nevertheless continue in full force and effect without being impaired or invalidated in any way. Binding effect. All of the provisions of this agreement shall inure to the benefit and be binding upon the heirs and personal representatives of the parties. Amendment, modification, or waiver. This agreement contains the entire understanding of the parties, and there are no representations, warranties, covenants, or undertakings other than those set forth herein, and no amendment, modification, or waiver of any of the provisions of this agreement shall be effective unless reduced to writing and executed by both parties. The failure of either party to insist upon strict performance of any provision of the agreement shall not be construed as a waiver of any subsequent default of the same or similar provision. So that last sentence is very important. The failure of either party to insist upon strict performance of any provision of the agreement shall not be construed as a waiver of any subsequent default of the same or similar provision. So for instance, let's say every time Destiny did an interview, just because LeBerick didn't remind her of what she signed doesn't mean he waives the fact that she shouldn't be doing it. He just, he's not obligated to say every time. So it kind of accumulated on her, honestly. So the same would go for her. If he was out here posting stuff on his social media and all this other stuff, and she didn't say anything the first or second time, doesn't mean she waives the fact that he can't say anything negatively on her. It's just that she hasn't said anything yet, but this always has to be enforced per the court. Incorporation of agreement into final order. This agreement shall be incorporated into and made a part of the court's final order, modifying the prior judgment of the court. Voluntary execution. Each party acknowledges that this agreement is fair and equitable, that it is being entered into voluntarily, and that it is not the result of any direct or undue influence. Each party has read this agreement in its entirety before executing this agreement. Okay, so again, voluntary execution. So obviously real life happens and people still sign stuff under duress, but for the sake of the contract, it is saying that they both determined it to be fair and equitable, it's being entered into voluntarily, and it's not the result of any influence. Prior orders of the court. All prior orders of the court herein not modified by this agreement shall remain in full force and effect. And that answered my question, because I was wondering about the stuff it didn't mention, and it had a lot of breakdowns in there. So everything else is the same. They just specifically modified certain things. And so the rest is still valid if they did not acknowledge a modification of those other terms. All right. And they LeBerick signed April 28th. Destiny signed April 27th. What did Dusty do before she married LeBerick? Is she educated? BABS. Why couldn't she get a job? In my brain, she does have a degree. In my brain. That's what I'm thinking. I think, though, that Destiny does look for easy ways out. And I'm not saying you can't have a soft life, but the other person has to also mutually benefit from it if you're gonna have a soft life, and they didn't work out, and she had to let these things go. It is what it is. You're gonna find somebody else that's gonna give you a soft life if that's what you're looking for. Because I don't begrudge anybody seeking the soft life. I don't. But it like somebody else said, a lot of these tendencies that Destiny does leans more towards scammer, and like it's just like, girl, just you gotta do something on your own until you find your soft life person, you know. But a lot of it is giving scammer, in my opinion. A lot of it is, especially to see in other court cases unrelated to LeBerick and see that she kind of pulls the same moves. I'm like, this is just her MO, in my opinion. Okay. Now we have, what do I want to go to? This is the last thing for this part, for part 3. Okay. So the clerk's deed. I don't see the date on here. Okay, but it says this clerk's deed made and entered into by Deborah Kaiser, clerk of the Circuit Court of Madison County, Alabama, as grantor, and LeBerick Williams as grantee, pursuant to the September 29th, 2023 decree of the Circuit Court of Madison County, Alabama. Okay. Witnesseth, whereas the real property hereinafter described has been awarded to the grantee plaintiff LeBerick Williams for the purpose of effectuating the sale of said property pursuant to the decree of said Circuit Court of Madison County, Alabama. And hold on. The undersigned was ordered to issue a deed to the purchaser of the real property hereinafter described, divesting the defendant, Destiny Williams, of all of her interests therein, now therefore. So that's when, at the beginning, when I was saying I saw that Destiny, by the end, it was the 11th hour, but by the end, she was divested of the deed. She, you know what I mean? So she had, her name was on there for a lot of it, but then the court finally said, okay, just it has to all go to the deed has to go to LeBerick only. The grantor, in consideration of the premises and under the virtue of the authority vested in her by the September 29, 2023 decree of the Circuit Court of Madison County, Alabama, does by these presents grant, bargain, sell, and convey unto LeBerick Williams, herein referred to as grantee, together with every contingent remainder and right of reversion, all of the right, title, claim, and interest of the said Destiny P. Williams in and to the following described real estate situated in Madison County, Alabama. To have and to hold the above described property with the tenements, appurtenances, here, oh my gosh, this is a new word. Real estate professionals, I apologize. Here didiments and improvements thereunto belonging or in any wise appertaining unto the grantee, his heirs and assigns, that he is lawfully seized in fee simple of said premises, that it is free from all encumbrances. Okay. This one isn't signed, but I'm guessing the other one, as we get to the other documents, will be signed by Deborah Kaiser, the clerk. Okay. Okay. I think that's it on the documents. Yes. Yep, that's it. Okay. All right. Kim said Destiny and Martell want to get rich quick and not get down and do the work. I agree. I agree. You see, every time Martell leans on friends to carry him, Destiny leans on, well, I was going to say friends, but that's not the right word. They lean on people that surround them and they play friend to see what they can get out of them, is how it appears to me. Cece said, I think it was telling when Moses said he knew LB wasn't Destiny's type when he saw pictures of him. Mm-hmm. Hey, Peaches and Cream. She has proven she does not follow the rules. He's the more responsible person. Aunt Natty. That's what she called it. I think Destiny did use those words, but Dusty thought that Good was going to mesmerize LB into taking care of her forever. Yep. I think so. So please don't forget to vote daily if you would like to for Melody for the Reality Queen. The link, Nightbot's dropping it. And it's just realitytelevisionawards.com. So you can keep voting if you would like. And we have YSL stuff hopefully today. But if not, I'll be doing the whole, what do you call it? I want to say mashup. That's not it. Like a blitz, a YSL blitz this weekend if I can't catch up because, the job and everything. So, yeah. But that's all I have for now. There will be a part 4. You can join Patreon for free to get better, reliable notifications of when I'm going live on YouTube. But we will have a part 4. Please go back and look at part 1 and 2. Some of them are short. Some of them are like 30 minutes. It's not a long one. Just so you can have all the details, because a lot of times if you hear snatches of audio and things, you may not have the full context and it might get misconstrued. So I do encourage people to see part 1 and 2 to see the documents, and we're following the timeline via the court documents. So, all right. That's it for now, but I will hopefully see y'all later today for YSL. But if not, we'll be catching up this weekend. Woody took the stand yesterday. I'm just trying to catch up. I'm enjoying it very, very much. All right, y'all. I will talk to y'all later. Bye.
I've been taking my time, taking all your time, taking all